Honorable Speaker, sir, thank you for the time. Today, I stand to make a statement under Rule 54, Clause 1, in regard to the traditional land dispute at Quezolza, which is a matter of urgent public importance. The ongoing dispute over the Quezolza between Marang, Mau, and Southern Angami communities has persisted for several decades and continues to remain a highly sensitive, contentious issue. Quezolza is a huge biodiversity resource, and the virgin forest had been under the traditional ownership and protection of the Southern Angami since time immemorial. However, since much theft of forest resource and destructions of forest were taking place, the Southern Angamis constructed a rest house to monitor, protect, and preserve the flora and fauna of the Quezolza. However, volunteers from Somsom village of Manipur destroyed the rest house. The matter of this incident was placed in the court of the Tenime Central Union, now renamed as Tenime Public Organization, to which in 2001 a landmark judgment was passed dated 14 February 2001, wherein the destroyed rest house should be reconstructed to its original shape by Somsom village within 20 days, and the order was implemented as directed by the then DCE. The Manipur government, under the patronage of Mau Council, in pursuance of a memorandum dated 23 April 2015, had illegally encroached and forcefully occupied Quezolza and deployed armed security forces and carried out massive permanent development activities, extracting and looting timbers, and plundering all resources within Quezolza, which fall under the Southern Angami traditional territory that has been preserved and protected by our ancestors since time immemorial. Following the 29 December 2020 inferno at Zuku, on the pretext of those in the fire, the Mau Council, together with the government of Manipur and its security personnel, took advantage of the circumstances and constructed road, installed electrification, and built permanent security station by way of forceful occupation and imposition of CRPC 144. On 13 March 2021, the TPO and the Board of Arbitrators, BOA, met the Honorable Chief Minister of Manipur and Biren Singh and apprised him of the prevailing situation at Quezolza. The Chief Minister immediately directed his Minister Sri L. Diko to immediately cease work and to withdraw all security personnel so as to allow TPO and BOA to adjudicate the matter on customary laws and practices. However, on 15 October 2021, the reconstructed rest house was again demolished by the Mau Council and the Manipur government security forces. It demonstrated lack of sincerity on the part of Manipur government. Furthermore, Manipur government continued to impose CRPC 144 since 11 February 21 till then. On 19 October 2022, TPO along with 9 frontal units of TPO went to reconstruct the Sapu rest house, but was denied entry into Quezolza by the Manipur security personnel citing 144 CRPC. Despite the intervention of the TPO and the BOA, the matter failed to reach an acceptable resolution of the dispute. The TPO court's verdict of 19 December 22 was rejected by all the contesting parties as it failed to deliver justice based on traditional and customary practices. Currently, the proceeding to resolve the matter has become frustrated due to the Manipur security personnel forceful occupation at Quezolza and illegal construction of security outposts without identifying the genuine landowners and restraining all civil societies, TPO, APO, and individuals from entering the territory by imposing prohibited orders under Section 144 CRPC. The imposition of restriction on movement through CRPC 144 and fencing with barbed wires along the arbitrary political boundary between the two states is unprecedented. This action represents a significant violation of the right of the people and is deemed arbitrarily and unlawfully. The restriction on free movement within the two states due to the fencing is a concerning development and raises questions about the legality and ethical consideration surrounding such action. It is crucial for authorities to address this concern and ensure that the rights and freedom of the people are respected and protected in accordance with the law. The Honorable Chief Minister of Nagaland has appealed to his counterpart in Manipur through an official communique dated 8 January 2021 to resolve the issue through amicable dialogue under the customary law and to identify the genuine landowners. But there has been no response from the Manipur state government till then. Three Nagaland government authorities, namely Nisapun Angami, Officer on Special Duty Border Affairs, Government of Nagaland, dated 23/10/2003. Zenipun Avimero SDU Jakama, dated 7/11/2012, and Rovilla Tomor, the then Deputy Commissioner Kohima, 29/5/2015, at different times who dealt with the matter, has acknowledged in their findings that the Angamis are the traditional landowners. The issue is a matter of concern for the people as our ancestral and traditional land lie across the arbitrarily drawn imaginary line of the Nagaland-Manipur political state boundary, which was drawn without the consent of the local dwellers. It must be understood that the dispute of this matter is in no way an attempt to alter or change any arbitrary political state boundary, although drawn without the consent of the local dweller, but to acknowledge the traditional owners of the land on whichever side of the arbitrary boundary it may fall. It is a fact that people have coexisted in their own traditional land much before any arbitrary state boundary, political boundaries was drawn. A case in point is the Okro-Ikro village of Mao people, which is within the Nagaland political state boundary, adjacent to Kusama village of Nagaland. While this village is within the political state boundary of Nagaland, it is under the administrative control of Senapati district of Manipur. This traditional ownership by the Maos is duly acknowledged by the Angamis of Nagaland and has never claimed this traditional land on the Maos, even though it falls within the political boundary of Nagaland. Not only that, since some portion of the Kusama TB Hospital of Nagaland government stand on the land of the Maos, even 15 posts of grade 4 posts were granted to the Mao people of Manipur by the government of Nagaland at TB Hospital as an acknowledgement of their ownership, even though Mao is not a recognized tribe of Nagaland. Such instances of traditional ownership across the arbitrary state boundary exist only in this Angami area, but also under Phet district of Nagaland. Key to drawing an amicable solution. Villages with their traditional ownership and boundaries have existed long before states were created by arbitrary lines of political and administrative conveniences. If the traditional ownership of land across any arbitrary political state boundary is acknowledged by neighboring government without ignoring the arbitrary state boundary, many of the inter-village land dispute will naturally dissipate. It must be noted that the Mao people has no traditional territory that borders with Quezon. This is acknowledged also by the people of Maramkulen, Sangkumai, Wilong, and Yangkulen of Manipur state, who share common traditional boundary with the Angamis and which is duly acknowledged by them. The Mao Council, in its memorandum to the Chief Minister of Manipur dated 23/2015, also clearly acknowledged that Kazolta is within Manipur's state political boundary. It is pertinent to note the findings of the then DC Kohima in 2015 that as the claim of ownership is explicitly based on ancestral ownership, but the political boundary of recent decade does not have any relevance on this issue. The Angamis, under any circumstances, cannot part with its traditional land, and this assertion has no conflict